Good evening, everyone. My name is Molly Arabolis. I'm a public defender. I'm the public defender for New Haven, and I'm moderating today's panel. It's my pleasure to welcome you to this segment of the Constance Baker Motley series on racial inequality, established by the Connecticut Bar Association and the Connecticut Bar Foundation. We look forward to continuing to explore topics related to racial inequality. Constance Baker Motley was a trailblazing civil rights attorney who became the nation's first African-American female to serve as a federal judge and later a chief judge. Judge Motley was born in New Haven, Connecticut, and maintained strong connections to Connecticut throughout her life. Today's session is entitled Race is Evidence, Exploring Discrimination in the Rules of Evidence. Before we begin, I will also ask that you view the chat function for this session's CLE codes and link to record the codes. We will be sure that the codes are read aloud. So at 6:15 and 7:15, I'll be reading them aloud and posted in the chat during the presentations. Additionally, at the close of the session, we hope you will provide feedback on today's presentations using the survey link provided in the chat. We have some great speakers today. Each are going to introduce themselves. I'll give you a general of them. First, we have Professor Jasmine Gonzalez-Rose from Boston University School of Law. Then we'll have Professor Bennett Capers from Fordham University School of Law. And then we'll have Professor Montre Cardine, University of Alabama School of Law. And so we're going to start with Professor Rose.
Wonderful. Thank you so much. I'm really happy to be here, and I'm going to get my slides ready. Fantastic. So my name is Jasmine Gonzalez-Rose, and I am a professor of law at Boston University School of Law and also the Associate Dean of Equity, Justice, and Engagement. And my focus is really on evidence law and race and racism. And so I'm going to start us off today thinking about why is this important? So why should we have a program such as this, examining evidence law, examining evidence practice under an anti-racist lens? So why even do this? One is that bias, including racial bias, can cloud truth-seeking. Also, race should not be a legitimate basis for making credibility determinations or liability determinations. Racial bias and racism are not legitimate bases for determining whether someone is liable or not. So it's not a legitimate basis of knowing, of believing, or of interpreting the facts. Also, we'll make an argument that structural racism in institutional and systemic forms exist in evidence rules and in evidence practice. And evidence rules and other doctrines are also employed in ways that replicate and perpetuate societal subordination. And ultimately, awareness of all of this can lead to us interrupting and mitigating it and increasing fairness in our practice. And so today, I want to ask a couple of questions. And even more importantly, I want to invite you to think about these questions, whether you're on the bench or a practicing attorney or an academic or a student. So can implicit racial bias influence evidentiary practices or rulings? Can evidentiary rulings or the lack of evidentiary scrutiny perpetuate racial subordination? And are there instances where parties have an unequal evidential burden, and that's unequal on racial lines? So let's go to the first question first about can implicit bias influence evidentiary practice or rulings? Now, implicit bias has to do with unconscious bias, stereotypes, and so forth, or prejudice that impact our thoughts, our decisions, our actions without our awareness or our control. And these can be shaped by socialization, by different experiences, even when we are all committed to equality and fairness. And often this results in in-group or insider preferences or expectations. And a lot of time, implicit bias is informed by systems of subordination that exist in our society. And this can be things like linguicism, which I had the great honor of speaking in one of these series about accent discrimination and other forms of linguistic discrimination in jury selection a couple years ago. We can think about racism, heterosexism, anti-Semitism, Islamophobia, classism, ageism, ableism, etc. And these systems can really inform some of our unconscious thinking. And so here are a couple of examples. One is how linguicism influences credibility determinations. Another is how dominant experiences can be expected while minoritized experiences can be rejected, and also unique things that occur determined by who the fact finder is. And so an example I'll give is in the summary judgment context. So a note about linguicism and credibility. There are studies that show that there is implicit bias on behalf of fact finders, often that witnesses who are non-native English speakers or speak in a accent that is perceived to somehow be foreign are deemed to have less knowledge, less credibility, and less intelligence. So that's one way to think about, who is providing evidence and how they're perceived. And race plays a big role in this as well. So, and then there's also been linguistic discrimination in jury selection, whether that's, a difference in speaking because of accent and so forth. Another example, and my role here really is to provide some of an overview to get you thinking about this before my colleagues, talk about some of the areas that they really specialize in. So what about as judges, as attorneys? We have relative power, we have relative privilege, we have access to dominant culture. Do we expect other people who don't have those same levels of access to have the same experience and to have the same conduct? So are witnesses able to fully testify in court? So before I went to law school, I worked with survivors of sexual violence, predominantly some intimate partner violence. And, as an advocate for survivors would tell me their stories, but when we would go to speak to the attorneys, and even more so at a hearing, in court, they were unable to tell their stories. They were unable to produce that evidence. And that's because of that environment they were in. And that was an experience that really brought me to law school. Another thing is, assuming that parties have the same ability to pursue internal or administrative complaint procedures. They may have demands on their schedule. They may just lack the ability to do that. They may be intimidated and so forth. And also, assuming things concerning trust with governmental entities or state agencies, such as trusting the police and trusting child family services. If there's a history or an intergenerational trauma, for instance, of displacement of children being taken out of the home. And so that's something to think about, how that dominant experience is expected and how minoritized experience really is rejected. Another example here is who are the fact finders? So who are considering the evidence? How do they hear the evidence? And so here are two cases. One, Harrison versus City of Dallas. The photograph here is from that case. In that case, the gentleman, Mr. Harrison, was having a health crisis, a mental health crisis, and his mother had called requesting transport to the hospital so that he could get back on his medication and get his symptoms under control and so forth, as it happened several times. And the police officers arrived, and ultimately they within seconds they had fired multiple shots into the victim, and he died on site, sadly, tragically. And here, the victim, he has a very small screwdriver that he was just twiddling aimlessly when the police arrived for transport to the hospital. And there was a video recording of this. And on summary judgment, the district court judge ultimately ruled that there were no facts, material facts of, in dispute, because it was clear that the police were, able to use, reasonable, police conduct here and so forth. When I look at it, it makes no sense to me. He seems to be confused. He seems not to pose any kind of threat in any way. And in this opinion, granting summary judgment for the defendants, the judge refers to Scott v. Harris, which is a U.S. Supreme Court decision that basically was very interesting because it said the video speaks for itself. Look at this YouTube video. And after, and that was a police chase, and it was a racialized situation as well. And Dan Kahan, a social psychologist from Harvard, did some experiments where it was shown that that mock jurors of that weren't white, that weren't male, that were of lower socioeconomic status tended to view the evidence very differently, would not be granting summary judgment and so forth. So when we're thinking about race, racism, and evidence, think about who are the fact finders. And then we can think about, can evidentiary rulings or the lack of evidentiary scrutiny perpetuate racial subordination? And here are some examples. Race and racism used as proof, racial injustice taking on evidentiary value, and dominant racialized experience giving preferential treatment. Again, that's a similar theme that I had spoken about. And so here, racial character evidence, and here, this is where how a person's race is used as de facto proof of their character. Are they prone to violence or to peace? Are they credible? Are they truthful or dishonest? And so this describes how race, in tandem with racial stereotypes, in tandem with bias, is relied upon and emphasized to establish the person's character propensity. And this can happen in different ways. One can just be an inherent reliance. Another can be stereotype emphasis. So for instance, whether there is dress, grooming, activities that are associated with certain racialized groups, are utilized to inflame racial stereotypes. So not just, okay, it's obvious that this person, maybe it's the defendant, maybe it's the victim, maybe it's another party, not only that they're a person of color, but that they're a type of person of color. So this happened in the Trayvon Martin case when George Zimmerman was prosecuted, where the the defense really wanted to bring in photographs of of the victim, dressed in certain ways or engaged in certain activities. So that's one. And also expert or lay opinion can also be a way, and I could talk more about that. There's also prior conviction impeachment. And here, I would argue this is where racial injustice takes on evidentiary value itself. So this is incredibly unfair when we think about how there's disparities in racial profiling, in stops, frisks, arrests, pleas, sentencing, every stage, right? Every stage, there are these disparities with Black and Brown people ultimately being subject to more police scrutiny, although not more behavior that is criminalized. And so here, when someone has a prior conviction that is used to impeach their character for truthfulness when they take the stand, this can dissuade them from testifying, or it can reduce the potency of their testimony. And this is particularly concerning for criminal defendants, right? For the accused who may be caught in this catch-22 of, if I don't testify, I know that it's less likely for the jury to believe me. If I do testify, my prior convictions are more likely to come in. And there's been social science studies into this. So, and one could say, this is reminiscent of 19th century race-based competency statutes that were pervasive throughout the United States, where people of color could not testify, or they could not testify against white individuals. And so here, reducing that ability to testify. We also see another example here, which is racialized reality evidence. And so that's evidence of how someone's experience in the racial hierarchy that exists in the United States really plays out. And so a good example of this is there's an alley, and at the end of the alley is a police officer. Do you feel more safe or less safe walking down that alley? Would you choose to say, oh, I'm going to walk down the alley, it's really safe because there's a police there and nothing will happen to me? Or will you avoid that because you know that any interaction or even proximity to the police could cause you racial profiling, it could cause you harm, it could cause some intervention by police into your life, and so forth, perhaps because you're a person of color subject to police brutality, perhaps because of being in a mixed immigration status in a family and not wanting to have scrutiny, and so forth by the state. And so the flight doctrine is a real example of this. How relevant is avoidance of police? It may just be preserving one's dignity. It may be a pursuit of safety. And how prejudicial is allowing that in when there is all of this, real racialized experience. And the racialized reality of a racially privileged group, such as white Americans, might be that they just assume like, oh, okay, only the guilty fleeth, and may not submit evidence to support that. So here, I think this is another example of how racism really interacts, and race interacts with evidence, law, and practice. We also see this when there is a preference or for dominant racial experience, such as white normativity. An example of this here is by adoptive admissions by silence. So a lot of times when we're looking at evidence law, we're asked to be lay psychologists, we're asked to be lay anthropologists. Like, what would a reasonable person do? Would they respond and refute some kind of allegation made by somebody nearby? Or would they not reply for a lot of reasons? And so here, how the dominant racialized experience can also play a role here in silence. So when we're thinking about the hearsay rule and the exemption for a party admission by silence, this is another example. And then another question here is, are there instances where parties have an unequal evidential burden on racial lines? Now, I talked about historically, race-based witness competency rules, there was clearly a very different evidentiary burden, right? It was very difficult for litigants of color to be able to bring evidence if they could not testify, or if they live in a racially segregated society where other witnesses were also people of color. And so that's a historical example, but does that continue today? And I say, yeah, I think it does. And one of the ways is, how do you prove racism? How do you prove the existence of racism? And so here, there's a lot of different ways that racism manifests. It could be affiliations and views, racist language, racist stereotypes, structural racism, implicit racial bias. It could be the impact of racism. It could be that racial trauma. And there could be also racialized history or application of law, policy, and practice. And so something that I've been very interested in is how do people prove racism? And there are many ways to do that. One way would be having an expert witness. Not ideal, but is that tool available? So I had the opportunity to engage in a survey of over 700 criminal defense attorneys from, across the United States. We got at least a couple from each state, and we collected data about the awareness of different types of anti-racist expert evidence. So here are experts who are talking about racism, explaining the impact of racism. Did they think it was helpful? Was there utility, and what were the barriers? And so here, what was really interesting was overall, aside from implicit racial bias, which was really known, a lot wasn't known. Overall, we found that attorneys, only about half had heard of or of this type of evidence, but about 90% thought it would be useful. And so I'm excited to share this in an article that's forthcoming. And there were also really interesting discussions about barriers. I assumed that the primary barrier would be cost, because experts are really expensive. But what we saw that was even more forceful were attitudinal barriers, particularly by judges. So judges being resistant to the idea that there is racism, and allowing this evidence in. And also, how are experts, certified by the court? Are they using really stringent, like the Daubert test, which was really made for the hard sciences, when proving racism has to do more with usually social sciences, sometimes humanities like history here. So I know I went through this somewhat quickly, but I wanted to give an overview about how racism really can impact evidence law and evidence practice, and how it's really important to think about that and be aware of that. So I look forward to the rest of the discussion and hearing from my colleagues. Thank you.
Thank you, Professor Rose, for that. I think there's a lot, as a criminal practitioner, there's a lot of things that make me stop and pause. We're going to move on to our next speaker, but if folks have questions, you can always enter into the chat and we can get to them at a later time. But next up to speak with us today is Professor Bennett Capers. He is a professor at the Fordham University School of Law.
Thanks, everyone, for inviting me. I always enjoy speaking to judges, and I have to say there's also special enjoyment I get when I can speak with on the same panel as Jasmine Gonzalez-Rose and Montre Carradine. I admire their work so much, and there's so much overlap and congruence in the things that we write about. So I'm going to tell you a little bit more about myself, because that might help contextualize what I'm going to say next. So as Molly pointed out, I'm a professor at Fordham Law School, where I teach evidence, but I also teach criminal law related subjects. I was a federal prosecutor for a number of years. And I'll also just mention, I'm also the director of the Center on Race, Law, and Justice at Fordham, and also the incoming Dean of Research at the law school. So mostly in my several minutes, I'm going to talk about an article that I wrote a few years ago. In the article titled Evidence Without Rules, I made the argument that in courtrooms every day, jurors rely on evidence that tends to get unnoticed by the rules of evidence, so tends to go unnoticed. Evidence that is rarely thought of as evidence per se, such as race, but also gender, dress, demeanor. And although we rarely discuss this out loud, jurors use this other evidence to decide whether the defendant should go free or be deprived of liberty. And if the rules of evidence exist to make sure jurors only hear and see relevant evidence that is trustworthy and not unfairly prejudicial, then it seems to me we should be deeply troubled when jurors base their decisions on evidence that has not been screened, that has entered unnoticed and unchecked, and that may be irrelevant, untrustworthy, and very much prejudicial. And race certainly fits that bill. So given my brief time and today's topic, I'm really just going to focus on one type of unregulated evidence today, and that unregulated evidence concerns race. So I'd like to start off by mentioning a refrain that's common in cases that obviously involve race. And that refrain is the assertion of the exact opposite. So from the trial of the officer who shot Philando Castillo, quote, this case has nothing to do with race. In the trial of the white officer for shooting an undercover Black officer, this case has nothing to do with race. From the trial of George Zimmerman, which my colleague just mentioned, for the death of Trayvon Martin, this case has never been about race. Even the disorderly arrest of Harvard professor Henry Louis Gates, after police suspected him of breaking into his own home, that was met by the usual refrain: this case has nothing to do with race. In fact, even more recently, Derek Chauvin for killing George Floyd. Chauvin's attorney stated the case was not about race. So I mentioned this up front to make an argument that I'm assuming will come as no surprise to this audience: race matters. But as someone who teaches and writes in the area of evidence, I'll take it a step further. As my colleague Montre Cowdein has argued, and consistent with the title of this panel, race is evidence. So I'm going to ask you to imagine a person is arrested. It could be for anything: possession with attempt to distribute, or burglary, or sexual assault. Imagine the trial. The arresting officer testifies about what he observed. Or maybe the issue is whether the defendant had the requisite mens rea to be guilty of the offense. Throughout the trial, assume race is never mentioned, but it would be foolish to think race is absent. As soon as prospective jurors walk into the room, race will likely be the first thing they'll notice about the defendant, even before they learn his name, even before they learn the charges. Even before opening statements or a single witness testifies, jurors, even the most well-meaning, will likely use race as evidence, and everybody knows it. So what does it mean to use race as evidence? Well, social cognition research demonstrates that implicit biases about race are practically universal. In particular, research suggests that we all have the tendency to implicitly associate dark skin with criminality. In fact, in one study of death penalty cases, they found a direct relationship with darkness and punishment, all other factors being equal. So as Jennifer Eberhardt, the Stanford researcher, put it, the more Black, actually the darker the defendant was, the more death-worthy jurors found him. There's also Justin Levinson's work adapting implicit bias research to test its applicability to trial settings. So in one study, Justin Levinson and his co-author gave mock jurors over 20 pieces of evidence to consider, all involving a robbery. One of the pieces of evidence was a still photo from a surveillance camera. And in the still photo, you could see the forearm and hand of the gunman, because the gunman was masked, so you couldn't see his face, but you could see the forearm and the hand. That was one of the 20 pieces of evidence. To test the role that implicit biases might play, some of the participants, when they were given these 20 pieces of evidence, For this photo, they were shown a photo where the forearm and hand reflected dark skin. The other participants got the same 20 pieces of evidence, but a photo where the forearm and hand were white skin. The study revealed that even though race was not part of the case, not mentioned, the darkness of the skin impacted how the mock jurors analyzed the evidence and their readiness to vote guilty or not guilty. And obviously, they were more likely to vote guilty when the photograph depicted a dark skinned hand. Consider two other studies in which mock jurors or participants are told about a confrontation between a couple of individuals. And they are told the race of the participants in this confrontation. And then later asked to recall the story, to repeat the story. Studies show that when the participants in these studies are told that one of the people in the confrontation was Black, those participants will recall the story and add aggressive behavior that simply wasn't in the original story they were told. All of this has implications for criminal justice and fairness. So one of the criticisms of implicit bias research is it does a good job of describing the biases we have, but doesn't really focus on explaining why we have those biases. But this to me is where our history comes in. People just don't wake up one day and associate race with criminality or aggressiveness. We all know, or we all should know, there was a deliberate effort after the Civil War to depict Blacks as criminals. For one, that made it easier for the South to recreate slavery by a different name, since the 13th Amendment, which officially abolished slavery, made an exception for punishment for a crime. The result was a host of Black codes and peonage laws and convict laws and then Jim Crow laws to reassert a racial hierarchy. But even before the Civil War, there were slave codes that ensured race would matter in terms of punishment and in terms of what was a crime. So, keep in mind that at the same time, it was not a crime for whites to hold humans in bondage or to rape them in order to increase their property. It was a crime for Blacks to move about freely, to gather in groups, to possess weapons. All of these laws have afterlives and inform our present. So there's one more aspect of this history that I'd like to touch on, and it dovetails what my colleague, Professor Jasmine Gonzalez-Rose was saying about credibility. And it's about those laws she mentioned and customs that prohibited non-whites from testifying against whites. And one thing I just want to emphasize, I think a lot of people, when they're aware of this, they think, oh, so it's Blacks. It's actually included Latinos, it included Asians, basically anybody who is non-white. In some jurisdictions, it was a blanket bar, and others, it varied. But one important thing is even after these laws became, dead letters with the Reconstruction Amendments, race was still tied to credibility. So North Carolina courts, for example, require that, quote, whenever a person of color shall be examined as a witness, the court shall warn the witness to declare the truth. The Oregon Supreme Court twice ruled that Chinese witnesses must be viewed with special scrutiny, stating in one case that, quote, experience convinces everyone that the testimony of Chinese witnesses is very unreliable. My point is that when we ask why things are the way they are now, why certain witnesses are given the benefit of the doubt and others are not, my point is simply this: history matters. There's one last thing implicit in everything I've said about race so far as evidence, and I think implicit in what my colleague Jasmine Gonzalez-Rose was saying as well, but I'm going to make it explicit. Just as we have biases that disfavor racial minorities, we have biases that favor whites. We link whiteness to truth-telling and innocence. In short, it's not only in cases involving minority defendants where race matters. Race also matters in cases involving white defendants, whom jurors are more likely to view as presumptively innocent, and cases involving white witnesses, whom jurors are more likely to deem presumptively credible. One more point, although so far my focus has been on how lawyers and fact finders use unregulated evidence at trial. This, of course, matters for plea negotiations as well. As you all know, lawyers bargain in the shadow of trial. So even in cases that are disposed of by plea, this unregulated evidence matters. So in my paper, I discuss other types of unregulated evidence and how that influences fact finders. Again, things such as gender, demeanor, dress. And I, in my paper, use all of this to argue that we should rethink the rules of evidence. I'm not going to give you my full argument about rethinking the rules of evidence here, but I will sort of tell you my modest proposal with respect to some of my ideas. And, you know, that modest proposal involves jury instructions and an evidence checklist. So the evidence checklist would basically be judges telling jurors, here is a list of all the evidence that was admitted. This is what you can consider. You can't consider anything else. And with respect to the jury instruction, it's really jury instructions about race not being evidence. So I think I'm just going to end it there. I'm really curious to turn the Zoom mic, I guess, over to my colleague, over to Molly first and then to Montre Cowdy. And I look
Thank
forward
you.
to the Q&A.
Thank you, Professor Keepers. You raised a lot of, yeah, really interesting things. And as a practitioner, like I had said earlier, a lot of things that we see every day in court practice. Next up, we have Dean Montre Carradine, who's going to be speaking. She is at the University of Alabama School of Law. And I'm just, you would think 4 years in, right? Zoom would be easier, but okay.
Hello, everyone. I hope you can hear me well. So I have the unenviable task of coming after two amazing scholars, two of my favorite scholars in the academy. And I'll try not to be repetitive, but to comment, like I said, there, you know, we have a lot of overlap. I think Bennett mentioned that in our work. So I'll go through my comments. I've been taking notes as they've been presenting. And there are some areas that I'll explore a little bit more. And again, like I said, try not to recover the same ground, but add value here. So just a little bit about myself and my interest in this area. I'm at the University of Alabama. I started out, I've been here for 17 years. I started out at Washington and Lee teaching, and that's when I first started to become interested in the intersection of race and evidence. I recall teaching Rule 609 in one of my classes, and there was a Black female on the front row. I'll never forget how frustrated she was with the material, and as best she could, because she didn't have the I think the language that she would have today if she were to be able to benefit from Jasmine and Bennett's and others' scholarship in this area. But she expressed her frustration with rules like Rule 609 written by members of the dominant sector of society that don't take into account the perspectives of people of color. And from there on, I started to think about writing in this area, following in the tradition of critical race theorists who had written, for example, like Cheryl Harris on whiteness as property, my colleague and mentor at Washington and Lee, Dorothy Brown, who's written about the intersection of race and tax, and there's so many others. There weren't scholars really writing about the intersection of race and evidence, not a lot. There was very little out there. There wasn't anything on Rule 609, which was my first article in the area. So it was really a lonely space at the time. And so it's just exciting to me to see all of these years later, the kind of proliferation of the scholarship in this area. I think it's exciting. It gives me hope. It's difficult when you're the one of the only ones or the only one writing in the area. I remember having a colleague who's since retired at the University of Alabama, who was on my tenure committee and wrote a review of my article on one of my articles on Rule 609 and race. And I remember him saying, something to the effect that she writes too much about race. She needs to focus more on evidence. And my response to him in my mind, and now even more loudly, is that race is evidence. I don't see them as distinct. And maybe that's radical. I don't know, but I see race as evidence. I see evidence as race. I really enjoyed Jasmine's presentation and her discussion about proving racism. And for me, it's there by default. I don't see how it could not be. It has to be. You have a system that was founded on the backs of people of color, the subjugation of people of color, and the courts facilitated it. They facilitated it through rules that were ostensibly race neutral, but we know who wrote the rules and we know who they favored. So it's there by default. It's remarkable to me that, for example, when slavery is abolished, and as Jasmine mentioned, those competency rules, when those rules start to be liberalized, that we pretend as if Black people and other people of color have always been there on the scene, participating fully in the court system. Not the case, not the case. And so in my mind, it's almost like, well, prove to me that it's not racist. Why is the burden on people of color when we know that the system historically and today is inherently racist? So, that's my background. That's the way I see it. That's my lens. That's my prism through which I see the rules of evidence. So I wrote an article on 609. That was my first race, intersection of race and evidence article. And I talked about race as character evidence and drew on history, looked at cases there. It's remarkable to look back at some of these historical cases and to see the language that was used. It was abundantly clear that race was considered evidence. In fact, race, color, skin color was prima facie evidence of the slavery status of an individual. That's embedded in our law. Bennett mentioned the Black codes, embedded in our law, the idea, the concept of race as evidence, evidence as race. They're not distinct, despite what my colleague said. They're not distinct. They are one and the same. In fact, if we zoom out and we think about the law, we often talk about race and the law. And, over the past few years, I've really started to reject it. I appreciate that language. I appreciate that that tradition, the foundation that critical race theorists have laid for us. But I see it even deeper as just race in the law. It's not and the law, it's in the law, it is the law. We have to think about it that way. When Bennett mentioned, Blackness as character evidence, but then the flip side of that, Blackness as bad character evidence, the flip side of that is whiteness as being positive. So there's all these benefits. It's always there. Whether a Black person is in the system, whether a Latino is in the system, whether Native American is in the system, Asian American is in the system. If we're not in there, if we're not in the case, and if everybody in there is white, there's still this white credit. That's what I called it in my first paper. I called it the white credit. We talked about the Black tax. I talked about the Black tax in my paper, but I also talked about the reverse of that, which is the white credit. Race is the law. So I want to get into talking a little bit about the rules, and then I always find the most valuable part of these types of programs is the Q&A, and especially when we are have the privilege of interacting with practicing attorneys. So I'm excited about that. So I won't be long. I jotted down some ideas that I wanted to to focus on and to engage with. One of the things when we talk about how to address these issues is I think we have the language already there in the rule. And something I've been thinking about lately is Rule 102, which is a basic foundational rule in the rules of evidence. It's a framework rule with those other general rules in the 100, that series of rules in the 100s. It says that these rules should be construed so as to administer every proceeding fairly, eliminate unjustifiable expense and delay, and promote the development of evidence law to the end of ascertaining the truth and securing a just determination. Okay. What does this mean? Okay. Fairness, we think about what it means to be fair. Obviously, it should be obvious, racial discrimination, racially discriminatory practices, both overt and covert, implicit and explicit, promote unfairness. Okay. And I go back to my point about it being there by default. The burden is put on people of color to prove it, but it's always there. And I think that judges should be proactive using Rule 102, which is one of the tools in their arsenal, to root it out. That ensures that every proceeding is administered fairly. Unjustifiable expense and delay are eliminated. And we promote the development of evidence law to the end of ascertaining the truth and securing a just determination. And speaking of unjustifiable expense and delay, any application of any rule that allows prosecutors to overcharge and overcriminalize segments of our society are by definition, to me, unjustifiably expensive and cause delays and clog up our system. Okay. And these rules like Rule 609, which I wrote about, do that. They allow prosecutors to alleviate their burden of proof, to use racist evidence. We know that historically and today, the system disproportionately targets people of color, particularly Black people. It has been, there's nothing really new under the sun. In fact, with Rule 609, it came about, the history of Rule 609. We got the rules of evidence in the 70s. I'll talk about that in just a second. But the precursor to that, to Rule 609 came about with the liberalization of the competency rules. That comes about post-Civil War. Black people, as Bennett mentioned, are being transferred disproportionately being transferred into the penal system, go from slavery to the penal system. In fact, I had one stat here. At one point, over 90% of the convicts in the system, in that early convict leasing program, were Black. Okay, so the courts were being used often by Southern states. The courts are being used as an employment agency for white plantation owners. That's what's going on. So if you think about it, so the people with records who the precursor to 609, that prior conviction impeachment rule is going to impact, those are disproportionately Black people. And there's nothing new about that today. And so going back to the framework of 102, where we are today, when a court sees that, the court should feel empowered, should know that they are empowered to address that. Okay. How it's addressed depends on the particulars of the case, but the court should have absolutely no hesitation in denying requests to have criminal defendants in particular, and witnesses generally, impeached with their prior convictions with attempts. They should rule that evidence inadmissible when they see the racial bias in operation. And oftentimes that's exactly what's going to happen. I don't have time to get into a whole lot of depth there, but I'm happy to talk about it in Q&A. But 102 empowers us. Going back to that point about unjustifiable expense and delay, when you're able to call on the usual suspects in criminalizing people, in investigating and resolving crimes. When you're able to use a rule like Rule 609 to substitute for good investigatory practices, in that sense, you're able to pull people into a criminal system, upending their lives, also clogging up our system and causing unjustifiable expense and delay. Our system is overrun. We've criminalized way too many people, and 609 is one of those tools by which we are able to do it. Going back to 102, we're promoting the development of evidence law. Okay, I have a lot that I've been thinking about when it comes to promoting the development of evidence law. Having a full and fair participation and equitable participation of people of color in the system, by definition, is going to promote the development of evidence law. We think about the history of the rules of evidence and the racial history. You can point to specific instances. There are cases where it's clear, where courts are using horrible racist language to describe Black people. We know that they're using race as character evidence, but there's also this omission that I've been thinking about lately. The omission of people of color. Think about those competency rules. Black people can't come in and testify, or if they're able to testify, they can't testify against a white person. The way the rules of evidence are developed have been developed historically is through precedent. The codification of the rules was a codification of common law that's developed by people bringing disputes or in criminal cases, cases being adjudicated through the system, through the participation, full and fair. Hopefully, you want it to be fair, but that's how it's supposed to be, the full and fair participation of citizens. We're excluded from that. People of color were excluded from that. And so we have a gap. A question mark. What would the rules of evidence be like if there had been a participation, a full and fair participation of people of color? So when we eliminate the biased application of the rules of evidence, to the extent that we can, I think because of the way our country came about and our laws have been developed, it's almost impossible to completely eliminate racial bias. But to the extent that we can, we promote the development of evidence law. We promote the full and fair participation of all citizens in the system, and we're going to get better rules. Okay. Let me see what else I'll just end on this. I think because I want us to have time for Q&A. And one of the things that one of my focuses for the past several years has been on developing different courses. I have a course called Major Race Trials, where I teach the concept of race as evidence, and we go from trial, case to case, trial to trial, historic trial to trial, and identify the historical and even modern use of race as evidence. I also teach critical race feminism. And by the way, I want us to always think about intersectionality issues when we think about race as evidence. Often when we talk about race, we kind of default to the male of color, but we have to think about women of color as well, and how these rules disproportionately impact women of color, the implications there. Think about the stereotypes associated often with women of color. I think about Black women in particular. There's the angry Black woman stereotype, the promiscuous Black woman stereotype. These things are replicated. They're replicated and reinforced in cases, and the rules of evidence allow that, and but conversely can be used to eradicate that. So I teach critical race feminism, and I also teach law and popular culture. And one of the movies that we study in my law and popular culture class is 12 Angry Men. And in that movie, I won't give the movie away for those of you who haven't seen it. It's a classic. It's consistently listed as one of the top movies of all time. And I use it in my race class because it is about race, although the race of the defendant, the criminal defendant, is ambiguous. So you can insert anybody, any group that's been othered in our society, and the movie takes place largely in the jury room, almost exclusively in the jury room. And the basic premise is you have kind of a juror who takes the lead, and that's Henry Fonda's character. And he's tasked with trying to turn around some really biased individuals who've already made up their minds. And I don't think it's so far-fetched. I think that's often how things happen in the jury room. And frankly, we often aren't even getting to, let's be clear, to be honest, we're not getting to juries. A lot of our cases are disposed of through the police system. So, judge and jury is often going to be the police and the prosecutors. That being said, though, Henry Fonda's character at one point says, it's very hard to keep personal prejudice out of a thing like this. And no matter where you run into it, prejudice obscures the truth. And so I go back again to 102, that very last part of 102. Judges ought to feel empowered using 102. Because the last part of it says, to the end of ascertaining the truth and securing a just determination. You cannot ascertain the truth when you have a racially biased operation of the rules of evidence. So I'll end there. I'm really looking forward to the discussion and engaging with my colleagues and with all of you. Thank you.
One thing I want to do first off is thank Dean Carradine for speaking. So now what we're going to do after we have listened to the great speakers and the great topics that they are incredibly knowledgeable about is we're going to have some questions that I'm going to ask of them, and then we'll open it up to the rest of you. So my first question, and it really is to any of our speakers, is what is the lens through which we should view the adoption and the development of evidence rules? I know that some of you spoke about that in a sort of general sense, but I'd be curious to know how you think we should go forward on it, because it is such a hard topic. So I'm curious to hear what you all have to say. Do you want to, okay, I can call someone. I feel like I can be the professor and call on one of you. Professor Capers, you're unmuted, so you can go. Well, you can start us off.
I'm happy to go first. I was assuming Montre would go first, but I don't know why. But I think, we're all going to speak, but I think we probably all have similar views. I mean, when you have a rulemaking body where certain voices are not included, certain people are not at the table, then it's not that surprising when the resulting rules sort of reflect a sort of myopic, they're myopic. They don't see the whole picture. They don't see what they're missing. And probably a lot of this is, just blindness. They weren't aware. I'm not going to go out and say like, oh, well, this person on the committee was, a racist. I don't know that, but I do know that they probably were thinking about, well, how is this rule going to play out on the ground, given this country's racial history? So I doubt they were thinking that. I hope they weren't thinking that. I'm trying to give them the benefit of the doubt. So I hope they weren't thinking that. So that's my 2 cents. I mean, I think one thing that all three of us are interested in, I think again, I shouldn't say I'm speaking on behalf of my colleagues, but I'll just speak on my own behalf. I think right now we're speaking to judges, we're speaking to practitioners, we're being kind of practical. But by the same token, we're law professors. And one of the pleasures of being a law professor is we can be a little bit impractical and a little bit radical. So I think the three of us secretly fantasize, maybe not so secretly fantasize, about completely reimagining the rules and trying to imagine, like, what would an anti-racist rules of evidence look like, for example. So I'll turn the Zoom mic over to one of my colleagues. Molly, I'll let you pick who you call on next.
Well, I was going to ask Professor Rose, because in your presentation, you kind of talked about who formulated these initial rules. And so the question is how, and I think Professor Capers spoke about that a little bit, how do we then move past that, right? Like, we have this foundation, even giving people the benefit of the doubt. As a practitioner, I see how that impacts us on a daily basis. And so how do we kind of go forward? And, I think in terms of an imaginary world, not imaginary, I don't want to say imaginary, but in a magical world where everything is fixed, what do you think are some ways in which we could kind of view that change to the evidence rules, or kind of taking these things into consideration?
Well, I think
And it's a very big question.
it's a big question, right? How do we fix it? So, I really liked what Professor Carradine said, right? I liked her reorienting us with 102 and this truth seeking and justice. I recently wrote a piece. It was more of a philosophy piece, but it was a critical perspective on testimonial injustice and looking at witness credibility excess. So looking at, because testimonial injustice in epistemology is this form of epistemic injustice where someone is not believed in their capacity as a knower. Like they don't, usually because of, social prejudice. Like, we're not going to believe this person because they're a person of color. We're not going to find them credible and so forth. And, exploring, well, what about that excess? What about that privilege? How does that privilege, face? And so thinking about that. And to me, it's really about getting to the fundamentals of what, this isn't an abolitionist perspective, but what are trials supposed to be? So if we're working within the existing framework, what are they supposed to be? It's supposed to be about truth seeking. It's supposed to be about justice. And if you're counsel and you want to win somehow, you're an attorney, you want to win, are you going to bring in stereotype emphasis evidence to win? Are you going to bring in a picture of someone, playing a certain black basketball, listening to hip hop music, dressed in, a style that's associated with, urban wear, someone might say, right? That's very race laden, which with the exact same folks are playing basketball and wearing certain clothes and listen to certain music have this credibility access. So I really think we need to reorient, and I think we really need to accept that racial bias exists and to question it and be aware and just kind of a refresh. What's the purpose here? Let us be really for truth seeking, and let's really seek knowledge and fairness. I think that's what I would think about.
No, I think it's a great answer. And Dean Carradine, I don't know if you have a follow-up to that, based on all the things that you kind of mentioned when you were speaking.
Well, I mean, going back to your point about the development of the rules of evidence, and one of the comments, it'll give me an opportunity to say things that I didn't want to, take up more time during my presentation to say, but to me, there's just a glaring omission in the rules of evidence of an open acknowledgement of the history of racism in our country and how the rules facilitated that. You just would think that a set of rules governing court proceedings in a country that historically used the courts to subjugate people of color would acknowledge that to ensure that vestiges of that prior system don't continue to infect the system. But it doesn't. I mean, it's very passive, and dare I say passive aggressive.
I would agree with you.
And not acknowledging that and putting the burden on us. And I'm like, well, why? You know, that's kind of, I go back to that point. And for, you know, I like the idea of a refresh, and let's zoom back and let's zoom out and think about it. Why are we having to prove what is clear in the historical record? That didn't just disappear. It didn't just go away overnight. 609 is a perfect example of that. And then let's fast forward a little bit to the 70s, where we get the rules of evidence. What's going on at the time? What's going on in the 70s? We have the beginning of the tough on crime era. I guess tougher. I don't know. I don't know. It's always been, kind of tough when it comes to people of color, right? But that's kind of that era where we get even stiffer punishments, longer sentences. The law is used to make it even easier to criminalize people, and that's the context in which we get the rules. Nobody really has to say what's going on. It's the context of it. You don't have to tell a fish it's in water, right? I mean, you know what I'm saying? It's just there, right? But even that being said, when I was looking at the history of Rule 609, and I said I would get back to this, so I'm glad to get an opportunity to do that. I had, in my research, I found there was one senator in particular who was fighting to not have any exceptions to Rule 609. And we have a few restrictions on Rule 609, modest restrictions. And this person's fighting for nothing, no restrictions whatsoever, and talks about, and again, think about the context. We're in the tough on crime era. We're in the black is criminal era. We got to, rein these people in, but this person says we've already gone far enough in giving every advantage to criminal defendants against society, to protecting them against society, protecting them against us. That's coded language. We understand who the them largely in that statement is referring to. Right. So there's a striking lack of participation, of full participation in the process, equitable participation in the process of people of color. But there are also comments like this. And when you put it in context, you understand exactly who these rules are going to hurt. I don't think it's hard. But again, we can ignore all that for a second and think about the glaring omission in the rules of evidence of the history, and the glaring refusal to frame the rules as tools to address that historical discrimination.
Do you have,
Molly, can I?
Yeah, go ahead. Yeah,
I?
absolutely.
Yeah, I'd love to actually pose a question to my colleagues, because I think this is something they know better than I do. Is recently, and they can correct me if I'm wrong, recently the advisory committee was presented with the opportunity to revisit Rule 609. And they were presented, my understanding is they know now, because they understand it has a disparate impact on Black and Brown people in particular, and yet they chose to keep 609 largely because the Department of Justice argued that they wanted to keep Rule 609. So that's my understanding. It might be wrong because I haven't been following it as closely as they have. But to me, that suggests okay, maybe even if, the original drafters, there was like a blindness. It's like, no, there's no blindness today. You know exactly what's going on. You know exactly how this is going to play out, and you're making a choice. Did I get that? So I'm asking Mark thing, Jasmine, if I'm getting this wrong, because I don't.
No, you're not getting it wrong. I mean, 609 makes it easier to convict people. It does, and we have a system that runs on the criminalization of disproportionately Black and Brown people. Criminalization generally, over criminalization. So let's be clear, it's over criminalization generally, and then in particular of Black and Brown people. And I wasn't really that hopeful that or I should say optimistic. I wasn't that optimistic because I know how powerful this is in the history and how it came about. And know that, so even in the face of all of this evidence that was presented, and I read through kind of the various memos that were directed to the committee, and all the research, all of the data, everything, and we still get this result. I'm not surprised. But again, when you we need a reframing, and how do you get there? That's kind of we have the I guess the benefit as law professors of kind of dreaming up these worlds, but how do we get there? I mean, I think that's why programs like this are so important. Um, we need more voices. We need more voices beyond the law professor, group. We need many more voices, and we need to engage the public. The public needs to understand 609. 609 needs to be discussed right alongside felony disenfranchisement, ban the box movements. It needs to be discussed right up there. Just because it's a rule of evidence doesn't mean that the public and those who are fighting for social justice shouldn't be talking about it. So, I mean, I just would encourage people to talk about it, in your spheres of influence. But yeah, back to your point, Bennett, when faced with all of this information, the Justice Department was more persuasive.
My hope is that there's still a chance, right? That there's still, but I'm very, I'm always hoping, right? I'm always hoping. And I think that, I mean, the decision hasn't been made, and when I hope it's inevitable that Rule 609, prior conviction impeachment, will be reduced and abolished, because it is so incredibly unfair. And so we really need more voices. There's still opportunities to comment on this. And also, in practice, being sure that the balancing test in 609, whichever one it is, depending on, is being applied. So balancing the probative value, and what is the probative value for truthfulness as a witness, and against the prejudice. And so thinking about, well, what is prejudice? And I think that racial prejudice is a type of prejudice. Racism is a type of prejudice. Why isn't that considered in the rules? And why aren't we, any judges out there demanding that that counsel, usually the prosecution, proves that the probative value for truthfulness, instead of just glossing over it and saying, we always allow these convictions in. And so there's things to do within the system. There's mechanisms to advance and to progress. And let's be engaged in that, because it really does matter, and it has real impact.
Professor Rose, when you talk a little bit about doing more things in the system, I mean, I would love, as a practitioner, I would love to hear what you all think that are things that we could be doing better. Or, I mean, again, I know this is an unusual situation. Practitioners sometimes get prickly when other people are like, oh, you should do this.
Right.
But I always find it helpful, because I think kind of being aware of the things, we kind of get stuck in a way of practicing or a way of trying cases. And I think it's always important to be mindful of things that we could be doing more, because I think this happens all the time. And the more that those of us on the ground can help the fight, better. So I'd be curious to hear from all of you, what are some things you think that we should be not only on lookout for, but ways that we could fight it a little bit harder in court?
Well, I think one of that is holding true to these tests, instead of just thinking the business as usual, they always let these convictions in. Another thing is looking out for what I call implicit judicial notice. So where the racialized reality of the dominant group, or the racially privileged group, often white Americans, is just taken as truth, as reality, versus asking them to have the same evidential burden as people of color, and produce evidence to prove that, for instance, flight from or avoidance of police is probative don't just assume that, because for many of us growing up in our communities or with our families, if you avoid the police is not an indication of any consciousness of guilt. So I think that's also important. The other thing is holding folks to the same standards. So thinking about expert witnesses. Often expert witnesses who come from carceral sources and governmental sources for the prosecution are allowed to testify. For instance, police officers are allowed to testify about a lot of things. They can testify about rap lyrics, right? And they're not music industry professionals. They're not musicologists, right? They haven't studied these fields, or counterterrorism activities. And then it's really hard sometimes to get professors who have studied these things and so forth to be certified, because there's a different standard of certifying expert witnesses. So really thinking about what is the test, how should it be applied equally, so there isn't this unequal evidentiary burden on people on racial lines. I think that's something that really needs to be done, and just raise that kind of awareness.
Thank you. I'd be interested to hear if our other two panelists have a thought, if they agree, if they disagree.
I agree. And I will also add, Molly, the older I get, the more I when I look back at my career as a prosecutor, sometimes I think that the defense attorneys were great, but there was also this norm of like not really attacking the credibility of police officers, for example, in a certain way, or a norm of, one thing I've read about, I think we all know it's normal if a defendant testifies, a judge will instruct the jury that a defendant has a special interest in the case, and therefore you should take the defendant's testimony with a grain of salt. So I just tend not to give a similar instruction when police officers testify. And it's almost like sometimes I wish like defense lawyers are much more aggressive, but that's just me. In
No,
hindsight, and I'm saying this as a former prosecutor.
listen, as a defense lawyer, I love the idea. I know that one of the participants is one of our appellate people. I'm like, I love the idea of a jury charge being like, police have a vested interest in what's holding their convictions. I know for those on the participant groups, I'm a defense lawyer, I'm a public defender, so I'm like, I love the idea of the jury being told that police have a vested interest, because I think they do. Yeah, drives me insane, but so no, I just wrote it down because I'm like, oh, that's it's a cool idea to try. I mean, get smacked down, but it's worth trying. I don't know if Dean Kerr, don't care, or Dean, if you have any thoughts in addition, or
I think this will be along the lines of what Bennett was saying, but it's something I was thinking about for today as well. Just I would say to defense attorneys to make sure to think about your own biases, and to make sure that some of these same biases that prosecutors, potentially jurors, maybe judges, that others in the system have, that you're not letting those blind you to certain issues in the case. And I was thinking, I think Jasmine mentioned the Zimmerman case, and maybe Bennett did too. I'll never forget in that case, Mark O'Mara called this woman to the stand to testify about her experience being robbed by, I think, two young Black men. And it was terrifying. She described it, really, really riveting testimony. Just had nothing to do with Trayvon Martin. He didn't commit the robbery. He wasn't one of the young men. There's no evidence that he committed a burglary at all, particularly in that neighborhood. And I kept thinking, why? I watched, watching a good portion of the trial. I just didn't see any kind of, to me, the aggressive cross-examination of that witness. or objection. And, maybe I missed it. Maybe there was a motion in limine I don't know about. I don't know. But I walked away with the impression that there wasn't much objecting. And I thought, well, maybe because you think the same way, you know? And so sometimes objections are missed and arguments are missed because you may have the same lens that you're looking at the case through, the same prism through which you're seeing your client, or a victim in Trayvon Martin's case. So in that instance, in Zimmerman's case, Trayvon Martin was the victim. So I would think, these same ideas, think about them and think really hard. You have to be self-reflective and self-aware. Where are my blind spots? Where are my biases, and address those so that you can effectively, represent your client.
Yeah, I think that's a great point, right? That comes up in a lot of defense trainings that we have about that implicit biases that we have, right? We're so worried about everyone else that we don't always turn into that lens, right? What it's like to be standing next to someone who doesn't necessarily look like us or didn't grow up where we did, and how that could impact the way that we treat them and talk to them, right? And so it's one thing that I see sometimes with lawyers. I always say to baby lawyers, I'm like, dude, if you're afraid of your client, if it looks like you're afraid of your client, what's the jury gonna think, right? And so I think that's a really valid point. We've been getting a couple of questions in the chat, and they're sort of related to our conversation. So I'm gonna do my best to paraphrase, because this is a lengthy one. So I'm looking to the screen to see if how I can paraphrase the question. And so it's in regards to how we're talking about how do we fix that. And this person, I'll just read it. Yeah, I'll just try to paraphrase as we go. And so this person says, we have all exist and involved within the system, yet we still bring our biases. We are notwithstanding the influence of our history and mass media. Can our justice system ever be reasonably unbiased in terms of evidence and racial discrimination? And so the question goes on. I mean, I think that's right. That's when we talk about being in professors and academia and sort of talking about these worlds and in practice, I think that is the question. Is there ever a place where we think that we can really get past that? And so I'd open it up. Dean Carradine, you're unmuted, so you can go first.
Yeah, because I keep thinking about Derek Bell and the permanence of racism. And Bennett mentioned getting older, something about getting older, and where you really see the wisdom of what he was saying. It's I don't think we're going to get there, at least not in our time. I think these are our times. And it was the Zimmerman case that's when I had the epiphany, my epiphany. He'd already, Derek Bell already told us this stuff, right? I read it in law school. And I just had an epiphany, and I just realized that, what's frustrating me so much is that we should be farther along than what we are, and we're not. And gosh, if we weren't farther along back then, think about where we are now. I live in a state that's passed a law that's saying that DEI is wrong. Okay? The DEI, that words like equity are dirty words. Permanence of racism. Derek Bell had a point. And then I, with the Zimmerman case, going back to that, I had that epiphany, and I was like, well, what does that mean for me? Like, how do you move forward? How do you have hope? Like Jasmine talked about being hopeful. And for me, it doesn't mean I don't stop writing. It doesn't mean I don't stop making arguments. It doesn't mean that I stop. I mean, it doesn't mean I stop doing those things. But for me, a big part of that is making a record. That a lot of times what we're doing is we're doing it for the record. And so back to your other question about practicing attorneys, your argument may be losing, but history is depending on you to make a record. Okay, we're not going to do this. We're not going to allow you to criminalize Black and brown people with our permission. We're going to do it for the record. But I'm sorry for the person who's asking the question. I do believe Derek Bell had a point that when he talked about the permanence of racism, at least for our time, I don't see it. I I don't see us getting to that eradication of these biases. I see us making gains. Derek Bell talked about making gains, but we're not going to get away. We're not going to get rid of it, not in our time.
Professor Rose, who was more hopeful at the start, are you still feeling?
It's true, right? So Derek Bell talks about the permanence and the pervasiveness of racism, and that racism is everyday life. And I think that that's really accurate. And I think what Montreal says is really accurate. And there are kind of two ways to deal with that. One is, to just say, why even try? And then another is to try, which I think what we're all doing, right? It's a Tuesday evening after a Memorial Day weekend, and we're here having this conversation. We're here thinking about how can we make, law better and better things better for our clients or for the cases that come before us. And so, doctors don't give up and say, well, you know what, there's always going to be human disease. So let's give up now. Or firefighters don't say, well, you know what, fire keeps happening, let's give up. It's like, no, we need to expend more resources. We need to dedicate ourselves to this more fully. And so let's do that, because even if we don't solve it, if we can make a case more equitable for somebody, that's going to help them, right? And it's a worthy fight, and knowing it's maybe not going to happen in our lifetime, well, all the more to work hard for the next generations.
And Professor Capers, how are you weighing in on this? A little bit of, yeah. It's a tough question, and I know you want it to be positive, but it's not always easy.
Yeah, it's very similar where it's we just have to keep trying and we have to keep working and enjoy the progress that we are making.
So there's another question on a little bit of a different tone from what we've been talking about, but the individual wrote in the chat, could you talk about how race can sometimes be introduced subliminally as bad character evidence through reference to particular neighborhoods or high crime neighborhoods that host gang activities, or that are also sometimes predominantly Black or brown neighborhoods? As is to say, if you came from a predominantly Black or brown neighborhood, right, there's a higher propensity for, I'm paraphrasing a little bit, but a higher propensity for crime and violence. Professor Capers, you want to start us off on that if you have a thought?
Oh yeah, I mean we introduce this stuff all the time. And sometimes it's pretty obvious, sometimes it's not, but we do this. So one thing I did in my article, Evidence Without Rules, and also goes to the other person in the chat who writes about like, oh, there are all these other things where we have biases. There are biases all over the place. So, and I don't want to go off topic, Molly, but I opened my article, I think, by talking about walking into a sexual assault case where the victim is dressed very modestly. She's been dressed for court. That's what we do. So we're always looking at signals. We're always reading things. One reason why race is particularly pernicious is because it's pernicious, and because part of what we've been trying to do in this country with the Reconstruction Amendments is undo that racial history, at least try to make amends for that racial history. So there's a big difference between, biases based on whether somebody's a smoker or not versus biases based on the color of their skin. We simply say one of these is more important, and one of these we're going to invest much more energy in trying to eradicate. But in terms of like trying to convey that to the jury, we do that all the time. I mean, one of the things I've been thinking about recently, and this doesn't quite answer your question, Molly, but I'm thinking back to the time when I was a prosecutor, and I did white collar cases, I did drug cases, I did gang cases, and those cases were very different depending on the race of the defendants. But one thing I keep thinking about recently is like, I introduced so many mugshots in my gang cases and in my narcotics cases involving Black and Latino defendants. And I'm trying to think, well, what was the purpose of the mugshot other than to show how bad and scary they looked in a particular photo at a particular point in time? And, clearly I was trying to benefit the prosecution by introducing those photos. And clearly it was all subliminal, but that's what we did. It's the same way in my article I talk about, telling my witnesses how to dress, whether it's law enforcement, whether it's a lay witness, telling my cooperating witnesses how to dress, like everything, we're always doing that. It's all problematic. But then going back to my first point, race is particularly problematic.
Yeah, I know the dressing, right? The people you want in the audience behind your clients, the language you use to describe a complainant. Like it's a vibe for sure. Yeah, I mean, I think even as lawyers, right, we're also super conscious about what we wear and how we're interacting with jurors, especially depending on who we are and what we look like as well, right? There's some stuff that goes into that. This is sort of in that line, but sort of off. What are the panelists' views, and maybe I'll send this to Professor Rose. When prosecutors, right, are using rap lyrics, or they're using to show kind of guilt or intent, right? Like we see this a lot, I think, now that more things are televised, right? We see the frequency of that. And I'm curious about what your thoughts about that, and if it should be, part of things that we talk about when we talk about changes to evidence.
Absolutely. I think that the example of the utilization of rap lyrics to establish bad character or even culpability, or to establish admission of a crime is really problematic. And there are studies that go back to the 1990s. I think it was 1999, where there was a study where certain lyrics were written out, and one group was told it was country music lyrics, and another was told that it was rap lyrics, and had to see how they perceive them. And by now in the program, you're going to guess the answer. The one that was perceived as rap lyrics was more perceived as more violent and so forth. So I think it's a real concern. It also brings in character evidence that's that kind of stereotype emphasis, like these are the type of people who engage in criminal activity, even though rap music has this long history where there is use of metaphor, even some of killing is like killing it, like being the top lyricist, and being, and sometimes it's just for commercial success, or it's to be provocative, or sometimes there are social justice themes. I mean, there's a lot of reasons, but it's not that someone's engaged in some kind of criminal conduct. And so the rap lyrics has been an area that has been really, really, really problematic.
And Professor Capers, I see that you're also unmuted, so I'm curious if that was intentional or if I just called you out. So I'll call you out and see if you have a thought.
I forgot to mute myself, but I will say,
gotta be careful with that mute button, man. I'm very fast on the take.
And when I think of rap lyrics, and when I think of everything else we've been talking about, what's implicit, and I'm just going to make it explicit, like one of the things that I think that annoys all of us is basically prosecutors are looking for shortcuts. Like we have no problem with prosecutors trying to prove the case based on real, admissible, relevant evidence. But I think what we all object to is sort of like lazy prosecutors. Like, I can't really prove this person's guilty. Let me show you a rap video. And you could just infer that this person had a culpable mental state, that this person committed the act. So I think that's what we sort of all sort of rebel against. I will mute myself. So
well, this is a question, and I'm going to pose it to Dean Carradine. Oh no, where'd it go? Sorry, all of a sudden my screen disappeared on me. Okay, so one of the questions in the chat has been, and I think the question is, has any work been done on whether judges or judges or jurors discriminate any more based on race than any other factors, like ethnicity, religion, politics, drug users, their job, that kind of thing?
I don't know of any.
And then, I mean, that's pretty. So then I'm going to move on to the second part of the question that I'm going to ask you for your thoughts on it as well. Is this person wrote that they find the presumption of bias and the special focus on race bias problematic. And the question is, by focusing on race, are you not exasperating the problem?
No.
I mean, I see Professor Rose is unmuted.
No, I think that it's good to raise this, right? So a traditionalist perspective is that, there is no more racism in the United States. That ended, back with Brown versus Board of Education. It ended with the election of President Barack Obama and so forth. And that the real problem with race and racism in the United States is race consciousness, race awareness, talking about racial differentiation and so forth. And so that's a traditionalist perspective, and it's out there, and that one has to grapple with. And I think it's an important question to ask. I mean, for me, and the way that I think about it is, I think it's something really important to talk about. I don't know of any particular studies, but what I do know is there's a lot of social science studies that show racial bias when they're controlling for all other factors. And so some of these factors would include some of these other identities and characteristics as well. And so we know race and racism are really are persistent. They're really influential in people's minds and so forth. And so in that way, I think it really warrants exploration. I don't think that racism is the only system of subordination that warrants exploration, which is why I shared the slide with 14 different types of, classism, sexism, heterosexism, ableism, anti-Semitism, Islamophobia, et cetera. Religious intolerance is something that's really concerning. All of these are concerning, and I know that, Bennett has written, really extensively around gender issues and so forth. So these things are all important, but I think these conversations, sometimes there can be resistance and then that way you can say, well, people will get tired of hearing about it, or they're not convinced, or but then I think that's not about talking about that. That's the reaction to it. And it is uncomfortable to talk about racism. It's uncomfortable to talk about all these systems of coordination, but I think it's really important and useful because we know they persist through all of this different research. And I really believe that, everyone, the bench and the bar, wants to have fairer trials. They want there to be determined on the facts at trial, not bias and not lazy prosecutors and lazy, defense attorneys and lazy whoever, right? Civil attorneys. And when we gave the example of prior conviction with 609, Valerie Hans and co-authors have shown that bringing in a criminal defendant's prior convictions to impeach their truthfulness actually is most persuasive in weak cases where there isn't a lot of evidence. And that's just not fair, right? We want things to be determined not based on race or racism. And so, I think these are really important conversations to have. And I appreciate the question that was asked. And there's other issues that are really important, but racism in the United States, some people call slavery an original sin, or if you go back to Johnson versus McIntosh and we think about, the discovery doctrine and how, the Native Americans and American Indians were, really treated as inferior and so forth. It's like, I think we have a responsibility as Americans and in our legal system to address this, even when it's uncomfortable or if we're getting tired of it. And it's not the only issue to address, but I think it's really important. And I just really want to applaud, Connecticut for having the Constant Baker Motley speaker series on racial inequality, so we can have these conversations.
I thank you for that. And I think you bring up an interesting thing, right? Sometimes when we have to talk about difficult topics, race or primarily being the biggest one, I think it is about other people's responses, right? And so my question is a little bit about when you all talked about change and getting up in a courtroom and making a record and preserving things, do you think that part of that is about making people uncomfortable, right? So that it is something that resonates. Like, I'm just curious. Like, I'm a big fan about talking about uncomfortable things when I'm on trial. Like, I'm like, let's just dive in. But I don't think that always works in my favor. But I'm just curious what you think. Dean Carradine, you're unmuted, so.
Well, yeah, I mean, it makes people uncomfortable, but I mean, I'm uncomfortable most of the time. I'm a Black woman teaching law in Alabama. First full professor, tenure professor here. I'm uncomfortable most of the time. I'm uncomfortable when I think about my son having, he's driving now. When I think about him, uh, on the road today by accident, his wallet, he left his wallet in my car. And I'm like, I had to find him, track him down and give him the wallet just in case he gets stopped. I'm uncomfortable most of the time. So yeah, it may make people uncomfortable. I didn't create the system of racial subordination. We were born into this system. I'm uncomfortable most of the time.
Are there I know I feel like that's such a strong emotion. So like I'm like I need a minute because it is true, right? I think it is, yeah, I feel the exact same way. So I'm like, sorry, I'm like, I'm having a minute. So I guess I'm gonna switch gears a little bit and ask maybe a more practical question. Other than, we've talked a lot about 609, are there any examples of rules that could be altered or reworked or tweaked to account for the negative effects of racial bias? Is there anything that you're like, oh, if I could change this, I would, and I would change it this way? And I know we spent a lot of time on 609, but there's a host of things I think that could. So, Jean Carradine, you're unmuted, so
Well, I
throw
mean,
it to you.
yeah, because I 404 may be worse than 609, quite frankly. And so 404, first of all, I think a lot of people don't understand 404. So we have all these, I think the casebook I use says it has more published opinions than any other rule of evidence. And so
Can I just interrupt real quick with a question for those of us that aren't as familiar with what 404 is? Yeah. I'm just like, just remind people of what 404 is.
404 is the general character propensity ban. So you're not supposed to use character to show that a person acted in conformity therewith on a particular occasion. There are what we call for those of us who use I think Bennett uses George Fisher's casebook, he calls it the routes around the box. There are ways by which you could use, when I say that, like somebody's prior acts in particular, not as character propensity evidence, but for legitimate non-character propensity reasons. But often litigants look at those as exceptions. And so they use character evidence to show motive, for example, to show identity. They use character propensity evidence to show those things. I've seen some really smart lawyers on doing commentary, like, in the context that I could think of in particular with the Bill Cosby case, doing commentary and calling those legitimate purposes under 404B exceptions. They're not exceptions. But a lot of racialized character evidence, to use Jasmine's language that she uses in her work, a lot of that comes in through violations of 404. So 404 could proactively take on racial bias. And I can't, and Jasmine, you may remember, I can't, her name, eludes me right now, but someone did an early race and character article on 404, I believe, The Color of Our Character, maybe. So I would check out that
Lisa
piece.
Thompson, is that what you're thinking?
Maybe, but
Okay.
but it was an early piece on 404. 608, sometimes evidence that can't come in through 609 is kind of backdoored through 608. So 608 deals with character for truthfulness, so impeaching someone with specific acts of untruthfulness under 608. 403, quite frankly, could openly, proactively take on race racial discrimination and bias. Jasmine talks a lot in her work, brilliant work, about flight evidence, and 403 is the framework for flight evidence within the rules. So, and I won't take up more time because my colleagues may have others that they want to talk about.
No, thank you. Thank you. Professor Rose?
No, I really agree with Montre, right? So thinking about prejudice, Rule 403, and that balancing, so often the idea of racial prejudice or another type of prejudice is not really brought in, and how damaging that is. Thinking about character evidence, including bolstering character. So if someone already has a character excess that because of racial privilege or something like that, how can we bolster character? Because usually you can't bolster character until it's already been attacked, and often it's attacked in kind of stealth, hidden ways. I talked a little bit about adoptive admission, so kind of that was just an example of kind of dominant cultural norms of how people are supposed to act and not act. And that's even more important when we think about racial reality evidence, that was flight and so forth, that people have really different experiences in the world based on racial hierarchy in the United States. And that continues, and that's, we can't always use the norm of the more privileged folks. I'm thinking about, whenever we talk about evidence, we have to think about the fact finder. Who are the fact finders, and what are their epistemic resources? What are their sources of knowledge? What are they thinking about? And it's been shown through social science research that juries that are more racially and ethnically diverse, that they deliberate more thoroughly, and that there's less expressions of racism and so forth. So who the fact finder is really matters, and that particularly matters when you're thinking about pleas, or you're thinking about summary judgment, where you have one fact finder. And still in the United States, we don't have judges that represent the racial and ethnic demographics of the country. So we have some groups that are disproportionately overrepresented, and others who are disproportionately underrepresented, and what are some of their experiences and so forth is really important. Again, we've talked about flight. And also about, who can be qualified to be an expert witness, and who can be a lay opinion witness in terms of talking about the lived reality of racism in the United States, or the lived class reality, right? So, when someone says they were going to get dinner at the liquor store, and someone who doesn't live in a food desert, thinks, oh, well, how can you believe them? Because I don't go get dinner at a liquor store. Well, that may be the only place that has anything to eat that's close by, right? And that, so, but if you have fact finders who can talk and be like, hey, of course, or hey, we call convenience stores liquor stores, and so forth. So these things are all important, and there's a lot of examples, but beyond the examples, I want to encourage people who are listening right now to find your own examples, right? Think about that, ask some questions, ask like, okay, are we assuming a white dominant reality? Are we thinking that everyone has the same racialized experience in the United States? Is our racial stereotypes being inflamed in the minds of the jurors with this? Like, is this fair? Is this fair? How can we make it fairer? And I think that should be all of us, in the legal system. That's what we should be doing, is trying to make things fairer.
I just want to add, and this is not so much focusing on particular rules, but sort of thinking about the discretion we give judges, and how that discretion is only reviewable for an abuse of discretion. So every time we tell a judge, you get to do the balancing between the probative value against the risk of unfair prejudice, we're giving that judge a lot of leeway in deciding how things are going to come out. Let's assume that judges, like everybody else, have implicit biases. I think it's safe to assume that how judges are going to decide that 401, 403 balancing, it's not going to be the same in every kind of case. And when I say every kind of case, I mean when people have different skin colors, when people have different backgrounds. That's just going to be there. And I wish I were the kind of scholar where I could like, have somebody compile all this information and do like, statistics or something, but that's not the kind of scholarship I do. But I think my intuition, which might be wrong, is even my intuition is the rules themselves sort of like facilitate or enable a kind of unfair outcomes through the loosey-goosey nature of Rule 401 and 403, which feeds into 404.
Yeah, no, I also love the word loosey-goosey. All right, so we have a question from the I know, everyone's like, why is Molly doing this? Okay, we have a question from the chat. One of the panelists spoke of jury instructions, which usually happens after the presentation of evidence, as a potential tool to address issues of bias or discrimination. Has any thought been given to a standard questionnaire to gauge the propensities of jurors in terms of bias prior to voir dire, to determine the inherent qualifications, of the potential juror to hear racialized cases? Whew. That's a lot, but I guess, yeah, Professor Rose, I see you're unmuted.
Yeah, so where I'm at it in Massachusetts, juror instructions on implicit bias are standard. So when you show up for jury duty, and I was so excited that about a year ago I got to serve on a jury. I never thought they would accept me, and they did.
Yeah, I'm surprised.
Yeah, I have a whole story with that, but why I think that happened. There was a very, very smart defense counsel who emphasized that the Boston mayor had included me on the police commissioner search, and so she just was like, so you're with the police all the time, all the police, as if I was the extreme on the other side, and the prosecutor was like, oh, no questions. So it's very, very clever.
I know that was some good jury work.
Yeah, not all.
Well, only if you acquitted as a defense lawyer.
Only all your critical race theory stuff. Now I'm kind of forgetting
So the question is,
yeah, Massachusetts, there is, and everyone hears it when they start. And then also, you can think about voir dire. I mean, and you don't ask people like, how racist are you on a scale of 1 to 10? Or like, if you're really racist, raise your hand and you're going to be excused. But, there's ways of thinking about if something is, for instance, let's say your case really hinges on a defense that a person of color, the accused was attacked by someone who has racist views against them, and they felt really scared. And there's a case I write about where someone had the number 211. The complainant had 211, the victim, and that was so affiliated with white supremacist prison gangs. And so that becomes really important, and it's important to have an expert testify about that. And so if there are folks who don't really believe that, that racism exists, they don't believe that there are white supremacy affiliations, and they're not going to look at that evidence with an open mind that that's possible, that's something you might want to explore in voir dire.
It's a nice opportunity to chat with people. You're right. It's very rare people are going to be like, yeah, I'm racist, unless they're desperate to get off. But even then, I think it's very different when you're in a room full of people. So we're winding kind of down, and as much as I could sit here and chat with all of you for hours, because I think everything you're saying is not only interesting, but it's also helpful as a practitioner. I'm just going to ask each of you if you could think of something you want to leave with the group. If there's some, if there's not, I mean, I know this isn't like, you got to give us some inspirational speech out there, but if there's just some point that you want us to take home, if there's some reading, because I know you're professors, so if there's some like reading suggestions, something like that would be really lovely. So Professor Capers, do you want to start with our closing comments?
Yes, I'm going to say people should read everything the three of us have written.
That's easy.
That's very easy. And then the other thing I will say, more directly to your question, Molly, is, years ago, a colleague of ours, Cynthia Lee, who teaches at GW Law School, really sort of advocated for the idea of people always thinking like, okay, well, imagine instead of this witness being white, this witness were Black or Latino or Asian? Would I view that evidence differently? And I think if people just constantly sort of ask themselves those questions, we can get closer to, even though Derek Bell talked about the permanence of racism, maybe that can get us a little bit closer to cases being decided based on real evidence and relevant evidence instead of prejudice. And that includes judges thinking that.
Yeah, I was about to say that too, right? Because it goes to, even as a practitioner, asking myself, am I treating this person a certain way because of the way they look? So I think, yeah, I think that's an excellent point. So thank you. Professor Rose, would you like to go next? And then I'll end it with Carradine.
Sure. I think that, looking at law, and particularly looking at procedural law, and evidence is a type of procedural law. If you ask yourself one question, if you're looking at a law or a policy or a practice, ask who benefits, who consistently benefits. And here, think about, are there any racial disparities? And the truth is that there is no superior racialized person, right? There's nobody that's more criminally inclined or less criminally inclined, more honest or less honest. There's nobody who has greater, morals or less, or commits crime. That's just, all people are equal in worth and value. And so saying, like, if time and time again, Black, Brown, and Indigenous people in the United States are benefiting less, that's something to think about. There's a problem here, right? There's a problem here. We can either blame people, or we can look at the problem of the policy, the law, or the practice. And so if I was going to say, walk away with one thing, always ask who benefits, who consistently benefits.
Thank you. And Dean Carradine?
What I would say is really what I've been saying the past few years to my students, is that the key to me, what I've learned in teaching evidence law, is that so much of it is about empathy for other people. You'll be able to spot these issues that we're raising if you can develop, to the extent you don't have it, true empathy for other people. It requires that you ask questions and then listen. Be a net listener. Listen to your clients. Listen to the parties in the case. Try to develop empathy for other people. And when I realized what a problem it is, the lack of empathy in our system, and a lot of it falls on us as institutions, the law schools, how we teach the law. We teach it in a way that doesn't really encourage empathy. But I'll never forget, I had a case that I've taught for years. It's in Fisher's book, Bennett, and I think it's the Johnson case. This young man witnessed a friend of his being brutally murdered. And he went to the police station that same day and wrote out his statement. Whatever particular rule of evidence, I think we were talking about recorded recollection, something like that. It didn't apply because I think maybe because he didn't vouch for the statement, something to that effect. But after maybe the 10th time teaching it, I wondered why they didn't try for excited utterance. Typically, they're not written, but there's nothing in the rule that says they can't be. And I just thought, how would I feel if just an hour or two later, after watching my friend be brutally murdered, shot in the head, and me almost getting killed, if I'm writing a statement, how would I feel? Would I still be under the stress of the excitement caused by the event, the startling event? Of course I would. Even if I talk about it now and I think about it and I have empathy for him, my heart is beating fast. And I'll never forget asking some of my students, and one of them said, well, he's from one of those neighborhoods. One of your questioners, one of the audience members asked about neighborhoods. Well, he's from one of those neighborhoods. They're used to that. Happens all the time. And I thought, the problem is a lack of empathy. If we can get that, so many of these rules, you'll understand how they should operate, and you'll spot these biases, and you can address them on the spot. And so to some extent, it's about rules like 404 and 609, being more proactive in those. But with others, like that excited utterance, it's about the application of the rules and how we apply it. And so much of that is based on empathy. And if you don't have it, or if you think you have it, you probably don't. I mean, I thought I had it, and it took me maybe 10 years to see that. So let's keep seeking empathy. Let's keep trying to understand what it's like to walk in other people's shoes. But thank you so much for having us.
Oh, thank you. I want to thank you all for joining us here this evening. Right, I think Professor Rose said, right, it's Tuesday after Memorial Day. So I think it says a lot about the participants. I also want to thank our speakers, Professor Capers, Professor Rose, Dean Carradine, for sharing their knowledge and expertise. I totally am on board with reading everything that they've written and are going to write. And I think all of you should be as well. I also want to thank the Connecticut Bar Association and the Connecticut Bar Foundation for holding this series, speaker series. We will have more information available about events in the 2025 Constance Baker Motley Speaker Series on racial inequality soon. Please see the chat for more information about today's events, as well as the session's verification codes and survey. Thank you all very, very much. It was so lovely to meet you all virtually. And I am looking forward to reading the work you do. And so I hope everyone has a fabulous evening. Good night, everyone. Or good night from Connecticut. I know some of you are not there, but good night.